This is an ABC News special report.
Good morning, I'm Whit Johnson. We're coming on the air because the Supreme Court has just handed down its final major rulings of the term. 24 hours after striking down affirmative action, the justices have now issued a significant decision concerning President Biden's student debt relief plan and a crucial ruling involving LGBTQ rights and free speech, both high-stakes decisions that will have lasting impact on millions of Americans across the country. We do begin here with the justices striking down President Biden's controversial student debt relief plan that would forgive student debts for more than 43 million Americans at a cost of $400 billion. Two lawsuits challenge the legality of that plan. Let's go ahead and bring in ABC's senior national correspondent, Terry Moran. Terry, break down the decision. And a lot of this had to do with the Biden administration overstepping its authority.
That's right. This is a huge case. As you say, 43 million people were eligible for up to $10,000 of debt relief under this program. The Supreme Court strikes that down because it says that President Biden and his Secretary of Education exceeded the authority that the law passed by Congress gave them. What the administration had tried to do was waive or modify the terms of the loans by forgiving the debt altogether. And what the Supreme Court says here, that is beyond the power of the president. Only Congress can waive that much debt, $400 billion, that it is such a large amount and such a sweeping assertion of presidential authority to modify the terms of the loans that way, that it exceeds presidential power, that Biden acted beyond his powers. In this opinion, the court saying, Chief Justice John Roberts, writing for the 6 conservatives on this court, saying that the administration had asserted the authority to cancel $430 billion of student loan principal, that had the authority to do that. It does not, is what the court says. That is a major question for Congress to answer. So this is a blow to all of those people across the country who were hoping that the Biden plan that had been announced last year to forgive these debts would be approved by the Supreme Court. It's not. The only place that the court says that can be done is Congress passing a law to forgive that much debt.
Terry, thank you. And stay with us here. Let's bring in ABC's senior Washington reporter, Devin Dwyer, because, Devin, just for a little bit more clarity here, there were 2 separate cases. There were a couple of people who brought their case forward, and it had to do with fairness. But at the end of the day, it was the rights of the states. And those states that challenged this, they're the ones who prevail.
Yeah, 6 Republican-led states brought the challenge to the Biden student debt relief plan. That's a significant subheadline here. The court affirming the ability of Missouri and others to sue the Biden administration to block this plan on a rather tenuous basis. The court today saying that because MOHELA, which is the nation's largest student loan servicer, is based in Missouri, it has ties to Missouri. Effectively, it gave Missouri what's called standing, the ability to bring this case. MOHELA, of course, would have suffered significant losses on its books if the Biden administration erased all those loans. So the court today said it would be impacted. Missouri would be impacted. But the bottom line in all of this, with students with all of that debt on their hands, federal student loan debt, will soon have to begin repaying those loans. There's been a moratorium on federal student loans for the past 3 years. The administration says those payments will now resume this fall. But good news for critics of this plan and those concerned taxpayers who are worried about the price tag of this proposal. Whit.
Yeah, it's been a real roller coaster for the students out there hoping to get some relief. Let's bring in Kate Shaw, our ABC News Supreme Court contributor. And Kate, part of the problem for the administration was the scope and scale of this plan.
That's right, Whit. So it's undeniably a very large plan and program, but the administration defended that size and scope by basically saying, look, Congress passed a statute giving the administration, the Secretary of Education in particular, the power to waive or modify the provisions of student loans in the face of a national emergency. And Justice Elena Kagan, writing the dissenting opinion for herself and the 2 other Democratic appointees, basically said Congress gave the administration this power and the court should not second guess based on its vision of what fairness looks like or how much relief is too much, congressional judgment to give agencies that power and the way the agency exercised that power. So in some ways, it's really a debate about the role of the court in second-guessing policy judgments by both Congress and by administration agencies.
Kate, thank you. Let's bring in Mary Bruce, our chief White House correspondent, who's joining me here in the studio in New York. This obviously a huge loss for the Biden administration. How are they reacting now?
This is a huge blow to the president. This was a major campaign pledge that he made and was hoping to be able to fulfill. A source inside the White House telling me they strongly disagree with the court's decision. The question is what comes next. This White House has been very hesitant to discuss any plan B. They thought clearly that this court decision was going to be their best shot at fulfilling that promise. But the White House is telling me now that the president is going to come out and speak on this later today, and that he is prepared for this scenario, that he will be announcing new steps. The question is, how sweeping will those steps be? Because, of course, there's only so much that the president himself can do. There are some possibilities here, though. The president can, I suspect you will hear him discuss his other student debt relief plan. This is a plan that he already put out several months ago. It's an income-driven repayment plan that would essentially cap the amount that a federal student loan borrower has to repay to 5% of their discretionary income, down from 10%. It is also possible that he could try and enact some kind of grace period on those repayments that Devin was talking about. They're set to begin again in October based on that debt deal that was agreed to a couple months ago. The question is, can he give people a little bit more breathing room here? Again, that's a solution that would just kick this down the road. One more thing. The president is going to make very clear, I'm told, that Republicans are to blame for this. He's going to try and pin this squarely on them as we head into the election.
Yeah, a message he hopes to take to the people to try to gain votes, but only so much he can do legally moving forward. Mary Bruce, thank you so much. We do want to pivot now to the other big ruling that we got this morning, handed down. This is the ruling on free speech case involving a familiar challenge here. The question whether businesses can refuse service to LGBTQ customers because doing so would violate the business owner's First Amendment rights. This was a 6-3 decision. The Supreme Court rules for a Christian web designer who objected to making wedding websites for same-sex couples. And we're going to go back to Devin Dwyer on this one because, Devin, we've seen cases like this before the court, but this one much more sweeping and broad.
A significant and sweeping decision, Whit, and surprising many of us who have covered the court on this issue from some time. You know, the First Amendment prohibits the government from forcing any of us from saying anything we don't want to say. At the same time, civil rights laws in this country say that businesses that are open to the public have to serve everybody. But what the court said today is that businesses, in some cases, can refuse to serve certain customers if doing so would force them to say something they don't want to say, like a business who designs websites, a stationer, maybe even someone who is landscaping your yard. If that is an expressive, customized, and tailored service, Neil Gorsuch said that the government cannot force you to do that business with someone that you don't want to do business with or something you don't want to say. Justice Sonia Sotomayor, who was in the dissent with the three liberal justices, said this is the first time in history, in her words, that the Supreme Court has granted a right to businesses open to the public to refuse to serve a member of a protected class. She says this decision threatens to balkanize the marketplace and even, Whit, in her view, could allow some businesses to refuse to serve, say, interracial couples simply because if doing so would force the business owner to say something they didn't want to say. So a striking and sweeping opinion. Justice Neil Gorsuch didn't articulate the limiting principle, if you will, for this this decision, and so it's certainly going to invite much more litigation down the line.
Devin, as you mentioned, the lack of limits as they're spelled out or not spelled out here raises a lot of questions going forward. It is worth noting that, again, what Sotomayor said in her dissent, she says, in her view, this allows a web designer to refuse to serve interracial couples if such a designer opposed interracial marriage. So, again, raising a lot of questions here going forward. Let's bring back Kate Shaw. And, Kate, legally, what does this mean for businesses and customers?
You know, this really is, I think, an enormous change. Justice Sotomayor, I think, is quite right in her dissent. You know, these public accommodation laws have a lengthy historical pedigree. They've been part of our federal laws for over 70 years. And in most states and localities, there are similar laws. And they just say that if you're a business and you provide goods or services to the public, you can't discriminate. And in recent years, discrimination on the basis of sexual orientation and sometimes gender identity has also been prohibited in many places, including in Colorado. And until now, the Supreme Court has never said that one of those laws violates the First Amendment rights of a business or business owner who wishes to refuse service to some category of customers. So I do think that Devin is exactly right that this case has potentially sweeping ramifications for the ability of business owners under some circumstances to provide services and to the ability of customers, I should say, to receive services on a non-discriminatory basis, in the public square. And it's not something that the Supreme Court has ever blessed. As long as we've had public accommodation laws, there have been objections, sometimes religiously grounded objections, and the court has never sided with those, has always upheld these laws. And so this is a very significant and I think very new rule the court has set forth today.
All right, Kate, thank you. I want to bring back Mary Bruce here because, Mary, now we have 2 losses as they could be perceived for President Biden. Only so much he can do, but again, a message that he would take to the voters.
Exactly, and we haven't heard yet from the president in response to this case. I suspect he will speak out forcefully against this. Of course, Joe Biden is someone who has spoken passionately about how everyone deserves to be treated equally with dignity and respect, no matter who you love. His administration has already passed new federal protections for same-sex couples, the Respect for Marriage Act. And of course, this is Joe Biden, someone who led a real national political transformation on the issue of same-sex marriage, coming out in 2012, surprising many with his support for same-sex marriage. That was a watershed moment in this country, as you recall, then forcing then President Obama to come out and do the same. But again, this is an issue where this administration, the Biden campaign, is going to hope to mobilize voters, drive them to the polls next November.
Mary, thank you. Let's bring back Terry Moran here because, Terry, we had affirmative action yesterday. We have these cases today. This is another defining moment for the Supreme Court and its conservative majority.
It sure is. And you see how much elections matter, right? Since these 3 justices appointed by Donald Trump have taken the bench, you've seen how fast and far the court can go. Abortion rights, gone. Affirmative action, gone. Today, a traditional understanding of public accommodation, that if you hold out your business as a public business open to all, you must serve all. The court limiting that today on the basis of free speech rights, and there's more to come. This is clearly a Supreme Court with the bit between its teeth, with the conservative majority not just in charge, but really eager to reach out and accomplish goals the conservative movement has had for decades. We're seeing the impact in law and in life in this country, and they aren't done yet by a long shot.
2 more major decisions at the Supreme Court. Terry Moran, thank you, and our entire team of contributors here. Of course, our coverage continues on ABC News Live and abcnews.com. I'll be right back here with the entire team for World News Tonight. For now, I'm Whit Johnson in New York. Have a great day.